Welcome to the Bail in the Midwest podcast, hosted by Shane Rolf.
Hello and welcome to the Bail in the Midwest podcast, where we explore a variety of topics related to bail, pretrial release, and the criminal justice system in the Midwest. My name is Shane Rolf. I'm the Executive Vice President of the Kansas Bail Agents Association, and I've worked in this field for the past 38 years. Now, we've talked a lot on this podcast about bail reform, and the idea of bail reform is often painted on the news as a product of the coastal elites, New York and New Jersey on the East Coast, and Los Angeles and San Francisco in the West. However, as long as I've been in the business, there have been bail reform battles being waged all over the country. Chicago was one of the first in 1965, and I've discussed the negative impacts there in past episodes. Kentucky and Wisconsin both did away with professional bail bondsmen shortly after Illinois did, and Milwaukee and Louisville have had extraordinary crime rates ever since. Two of the major defund the police incidents, Kyle Rittenhouse and Breonna Taylor, happened in those cities respectively. But one place we didn't really associate with bail reform, at least in the public mind, was Texas. But truth be told, Houston has been an on-again, off-again battleground for bail issues for the entire 40-ish years that I've worked in bail. The Professional Bail Agents of the United States was actually founded in Houston, Texas, in response to early attempts at bail reform in Harris County. PBUS is now a nationwide organization that has surpassed its founders. In the 90s, in response to the prevalence of crack cocaine and the accompanying crime and violence, Texas, like much of the country, moved away from the lenient pretrial release policies of the 60s and 70s that had resulted in a quadrupling of violent crime since the Bail Reform Act of 1966. But as the jails filled up and crime came down, Harris County was dragged into another round of bail reform by the U.S. District Court in the O'Donnell versus Harris County lawsuit, which resulted in decisions requiring, at least initially, to release virtually all misdemeanor defendants on zero bail or a personal bond, which is functionally the same thing. So does history repeat itself? Have the results post-O'Donnell been all peaches and marmalade, to quote a character from the new Fallout series? Or does this ultra-lenient release for accused criminals bring less utopian results? Our guest today has had a front row seat to this. Kim Ogg, DA Ogg, is the current district attorney for Harris County, Texas, and has been for the past 7 years. Kim, welcome to the podcast.
Thank you, Shane.
So give us a little more of your backstory. I kind of threw out that you're the DA, but how did you become the DA for Harris County? It's a position that's been described as the most powerful prosecutor in Texas. It's one of the largest counties in the entire country. So give us a little bit of your backstory.
Well, the path to district attorney starts at my childhood. I'm a native Houstonian. My father was in politics. He's a lawyer, and ran for state representative and state senate and served for 16 years. So I grew up in politics, which of course led me to say that I would never, ever run for office, much less as a lawyer. The law was something I chose after I had majored in journalism, and that was such a difficult profession for me and such a financial failure. I decided I really needed to think this thing through. And I went to law school here in Houston, South Texas College of Law, graduated and became a prosecutor here, a line prosecutor in 1987, where I served for almost 7 years. I stayed in public safety. From the Harris County District Attorney's Office, I was appointed to a new post by then Mayor Bob Lanier of Houston. He was a conservative Democrat, very interested in public safety, ran on it. And I had been making headlines for prosecuting gang crimes. And so he decided we didn't want to be Chicago or LA, and he appointed me anti-gang czar of the city. And I held that post for about 6 years. The title was director of the anti-gang task force. And we worked on policy, legislation, and programming. And it really gave me my first taste of governance. And it was fun to work for a great leader like Bob Lanier. I left there and I went to Crime Stoppers and ran a nonprofit, again, criminal justice oriented, against crooks, for victims, trying to solve crimes. So you can see the pattern. I stayed with, in a sense, the prosecution side. after I ran Crime Stoppers, which was successful and really interesting experiment in partnerships to protect our public, I went into private practice as a lawyer. And so I practiced for 10 years in various areas. I did not focus on criminal defense. I didn't feel it was my strongest suit, but I was a litigator. And so I tried all different kinds of cases. I had always wanted to run for public office, but the political scene was rough on both sides. I'm a member of the LGBTQ community, and gay people really didn't get through political primaries back in the mid 2000s until Mayor Anise Parker set a new trend here. And so I was motivated to run, and I ran in 13 after the then current DA, Mike Anderson, passed away. His wife was appointed. I ran against her. She defeated me, but had to run again in 16, and I prevailed. So it's the only office I ever really wanted to run for, especially after that childhood promise to never go into politics. But you could see that the trajectory that I had was public safety. It was victim oriented. I'm a litigator, so I'm not really judicial material. I'm an advocate, not an umpire. And bail became a prominent issue in my administration almost immediately. And it's remained a prominent issue, both operations, in terms of operations, and politics. And so the weaponization of the bail issue politically has been we've really been at the epicenter of it here in Houston. We're a jurisdiction that I think the folks who are really pushing bail reform at every level have wanted to take. We're the third biggest county in the country, most populous. And what happens in Houston to a large degree directs or previews what's happening all over Texas. So we've had quite the debate about the impact of bail reform on criminal justice, on public safety. Understand, I was initially for bail reform, and what I've learned is bail reform is a term of art. It's not a legal term. And I think there are things we could all agree on. Example, we don't want poor people put in jail or kept in jail simply because they're poor. But likewise, we don't want bail decisions made without adequate consideration of public safety. That simple, just a balancing of the interests. But, that goes against the political extremism of the day, which says sort of all or nothing. We either have to have all bail reform, no jail, no bail, or we have this draconian racist system where that's wealth-based. That's how I think the extremists describe the bail system. So I know you've been in the business 30 some odd years. I've been in the business 36 years. I see the bail industry as an integral part of the criminal justice system. I've never known a justice system without it. It certainly has an impact on public safety, and I think those things are worth discussing. And many elected district attorneys, especially those of us in the Democratic Party, are under a lot of pressure to agree with these bail reform ideas. The farther they go, the more pressure there is. So understand that when I was first introduced to bail reform, it was a far gentler thing. It was focused only on misdemeanors and not misdemeanors of violence. And boy, have we seen a major push toward no jail, no bail, not just in Houston, of course, but nationwide.
Right. Well, it's always the camel's nose. It's like, we'll get in with this one thing. Well, you can't, it's just misdemeanor. It's just this trespassing. You're urinating in public, or some little minor thing that, well, we don't want to lock people up for that. And then once you get in, then the entire camel comes into the tent. And so now you did bring up a couple of things there. I almost thought I was going to have to take notes there. You indicated that you were, an advocate and not an umpire, but it certainly seems to me from watching, Houston from afar, that there's a whole lot of advocacy going on at the judicial level as well.
Well, of course, they are the umpires in the criminal justice system, but we have seen some very result-oriented action by some of our jurists. We had a change in our jurists in Texas are elected through a partisan primary system, which, as you may know, is producing all kinds of extreme results in the parties. Look at our national scene. So we saw a change in our judiciary from a more conservative rule of law judiciary pre-2017 to an extreme change beginning in 2019. The 18 elections were definitive. Beto O'Rourke led the ticket here in Harris County. And as a result, in 2018, every single Republican office holder in Harris County, which is Houston, only greater, the greater Houston area, was defeated. And so while I don't blame this on, I don't believe that Democrats want dangerous streets. I think we have a partisan system that has allowed the election of people who do have strong, defense-oriented, and this type of reform mind when they're running for office. I, in part, ran on bail reform, but it was a much different animal the way I understood it and promoted it and supported it. But what I saw is almost an immediate change and it began January 1 of 19 here in Harris County. So judges began releasing many more people on different types of no cash bond, and far fewer. The corollary that I saw, and the one that was most concerning, was we saw our most violent offenders, some capital murders, being let out on very low, insufficient bonds. And there were murders even let out on PR bonds. So there's been a lot of attention brought to the crimes committed by offenders on bail. A TV program was birthed out of the controversy. It's called Breaking Bond, and it's on our local Fox station, which is not nearly as right as the national Fox News. It's local, always been heavily local, and they put these stories out, and that show does well. Occasionally, they'll name names of judges. That does have some impact, and the legislature has gotten involved. While we have a heavily blue county, we have a very red state legislature. So we've seen regulatory measures on the judiciary and on prosecutors come out of Austin through our legislature. And some of those changes did affect bail reform, and some affected it in a positive way. But there's definitely a partisan divide. Our Democrats seem to feel like bail reform, however described, is a good thing. And I'm simply a Democrat saying the devil is in the details. So when you go to actually look at criminal cases, you got to look at each one individually. That's the nuts and bolts of our system. So this idea that everybody should be released pre-trial without any security has been a dangerous proposition, and it's affected our public safety in a negative way.
So since O'Donnell, I mean, and it's just a little background on O'Donnell. This group that brought O'Donnell, they had filed multiple other lawsuits around the country. But normally what they had done is they had focused on small cities that didn't have a whole lot of resources. And so they would sue them and claim that there was some sort of constitutional violation. Those cases never actually went to trial, because one of the peculiarities of federal law is that if you sue under a civil rights claim, and even if you lose and your claim was completely frivolous, if you sue the government you can't get the government can't get attorney's fees from you for a frivolous lawsuit. And so there was really no downside to these groups suing these small cities, because they didn't have the ability really to come up with $1 million worth of defense attorney work to try and defend those types of lawsuits. And so they forced them into settlement agreements. So that was one of the things that there were two big cases where they took on large areas. They took on Harris County, Texas, in the O'Donnell case. And initially Harris County was opposed to it. And I'm like, yay, go Harris County. Now we have someone with the resources and the ability to fight back on this. The other one was the Buffin case in San Francisco. And that started off the same way until the winds began to shift politically, and Kamala Harris was the attorney general at the time and decided that, bail's not popular politically, and she refused to defend the lawsuit. So then we were just left with Harris County, we were still going along. And
I think I can offer a local explanation for that.
Okay.
we're a desirable county for either side, pro-bail reform or anti-bail reform, because we're so large. And what we do matters to the largest state in the contiguous United States. And we have a political scene that shifted dramatically. The pendulum swung from a totally red county all the way through 16 to a totally blue county by 2018. Now, that pendulum swing took 20 some odd years to effect, but it was complete. And Beto O'Rourke was largely the reason. Harris County turned out to vote for him in this big urban area. And when they did that, they voted down the ticket democratically. So you got a bunch of judges who had run in part on bail reform, and boy, they meant it. And they came in with some radical actions, and we saw a major change. Now, why did we get sued? We already had elected a judiciary that was adopting a local rule that would change bail practices here that had been established for 40 years.
Right.
The O'Donnell lawsuit gave cover politically to the judges who did it. It also gave cover to our commissioner's court, which went from a red commissioner's court to a blue commissioner's vote. Instead of a 3-2-R vote, it was a 3-2-D vote. It gave them cover to spend $94 million on public defenders, new courts, all kinds of rights, a 24-hour court for defendants. These things sound great. There was not a single dime for public safety. Pretrial services, the key to these free bonds, is understaffed and underfunded. So it's unclear where the money went. But the O'Donnell settlement, when the court shifted from red to blue, their position on the O'Donnell case went from we're against O'Donnell to that of a friendly defendant. We're for O'Donnell. Let's settle. And that's what happened. Now, luckily, Dallas had a lawsuit. They fought it. It went to the Fifth Circuit, and they won. It's been found that the bail system is not unconstitutional, and I think it leaves the door open. I think the parties in O'Donnell have moved to appeal once again the rulings that would really dismiss not dismiss, but effectively stop O'Donnell. I think that's just to keep it on the books, to keep this major effort to free people without security. I think that's what it's about. And the delays in the lawsuit, the appeal after appeal after appeal of this Dallas case. So anyway, I think what you saw here was a political move more than a philosophical move toward bail reform. In fact, the public doesn't understand bail reform. It sounds so good. When you look it up on the internet, every study you read says it works. And so the public is confused, and the media has been telling us that crime is down. Well, again, another local issue. Our police weren't counting all the cases reported. And so we see a kind of a party line that says crime is only a Republican talking point. But as the district attorney, what our staff has been seeing has been a big change in crime, an increase. Yes, it's decreased since the pandemic, but the pandemic put us at a 30-year high in terms of homicides and other violent crimes. So you're seeing a propaganda war fought politically about what is, in essence, an operational issue in criminal justice, bail, which should be determined individually based on the circumstances of each case and each person.
Well, and a multifactorial decision as well. It's not just how much money you have in your pocket. It's, what's your history of appearance? What's your history of violent crime? Are you a danger to the community? Are you a danger to the witnesses? Kansas has 13 different factors built into statute that the courts are supposed to consider. Finance is one of those, but not the only one, and certainly not the most important one that the courts are supposed to consider. But it seems like it comes down to that argument when you're dealing with political.
It does. And race is injected into the argument, which is like throwing gasoline on something. I mean, we clearly have more minorities in the criminal justice system. I don't think that should be denied. I think that that's an important factor. Why is important, but it doesn't really change the analysis on bail, which should be individualized. So this movement to me is more political than operational. Operationally, the studies show crime unfortunately increases with this form of bail reform. This form meaning both misdemeanor and felony, where you have a lot of free bonds, personal recognizance bonds. They have a multitude of names here in Harris County. All of that confuses the public.
Right.
I think they just don't understand our system, but they can see crime becoming more violent and frightening. It doesn't match with the news reports that crime is coming down. It doesn't match with our local program about breaking bond, where you can see somebody's been let out on 18 bonds. What? I mean, that the public can understand. That shocks them. And they don't want that guy living next to them. So what we often contend in terms of race is look at the evidence where folks are living. They're not coming back into the wealthy neighborhoods when they're on a PR bond. They're often staying with a relative in an area that is less fortunate.
Now, you mentioned that the devil was always in the details. And in 2019, your office released a report called Bail, Crime, and Public Safety. And some of the executive decisions on there, the executive summary, was that reoffending by criminal defendants was up on bail. That's one. Bail failures are up, and I assume that means failure to appear. And violent offenses committed by defendants are up. Now, when I kind of read through the report and pulled it out, the report reflects that while the rate of recidivism increased by just a few percentage points, that because the numbers of releases were dramatically increased, in raw number terms, the increase in crime was striking. The use of misdemeanor personal bonds, which was mandated by O'Donnell, resulted in the actual number of misdemeanor defendants who reoffend increasing by 18 times for 90-day reoffenders. Now, if I do my statistics and math, that's an 1,800% increase in total offending. I think it went from 6,000 instances to over 10,000 instances or something. Anyway, it was ridiculously high. So just looking at that, a couple of questions. How can the court monitor, because there was a court-appointed monitor to kind of look at all this, how can they claim that there's only a 1% to 2% increase in recidivism under bail reform?
Well, you know what they say, 50% of statistics are made up. We work with the bail monitors. They're honorable people. They do clearly have a philosophical bend toward bail reform and have written on the subject, testified on the subject. So while we believe them as folks who are intending to present a clear picture, we found that statistically, they often included or didn't include critical data that really, if you looked at it in terms of how things actually play out, would have changed their numbers. To me, the biggest deficit of the monitors who make $100,000 each year is that there's no actual way that the courts uniformly count the failures to appear. Now, why is that important? Well, it's the basis of everything that they're studying, really. So the last time we met, which was last year in the fall, they readily admitted, although I don't find it in their reports, that there is no uniform method of counting failures to appear. Why is this? Well, historically in Harris County, we use the bond forfeiture numbers from each court each year to determine how many people showed up for court or didn't, failed to appear. When the judiciary changed in 2019, we saw an array of options that judges began utilizing when it came to revoking bond. They would surrender bond. They would not revoke bond. They would grant continuances. A lot of different things happened that really eliminated the consistency among courts and eliminated the ability to track numbers, how many people didn't show up. And while I thought the monitor's job would be to fix problems like that, my frustration with the monitors in O'Donnell is that they did not attempt to even fix any of the problems that we saw with the implementation of O'Donnell. So I think that they should be more than good news reporters. I think that they should be auditors who provide solutions to real problems, and not being able to count who shows up in court because you don't have a consistent way of working among the courts is where I would start. So that was my biggest frustration with them. While I like them, I found their reports frustrating. That's in large part why we did this report. Now, it varies from the Yolo County report by D.A. Reisig.
Right, Jeff Reisig. We interviewed him a couple months ago.
In that he had a different approach. We focused on misdemeanors and some felonies, but he focused very specifically in a small area, but he got a good sampling number, over 100, and he was able to definitively show an increase in violent offenses. We were able to do the same thing, but I thought his report was concise. I thought it was clear. We're both saying the same thing, that the evidence shows, since we're prosecutors and lawyers and bound to evidence, that as we gathered data about what our lawyers were seeing and our crime victims were enduring, we saw a correlation between violent crime and, I'm sure, property crime, although we looked at violent crime, and the way bail reform has been implemented here in the third largest county in the country. And that's a problem. And I've been politically just excoriated for these statements. And there just seems to be a reluctance to look at our data and even consider it in the mix. And I think that's a real problem. The research that's being done on bail reform has the feel of they know what the answer is and they're out to prove it, as opposed to let's really research it and see what this shows us. What's happening in America? You know, why in 2020 were there 92 sexual assaults committed by people out on bond when in 2015 there were 23? I mean, that matters to those 70-some rape victims.
Absolutely.
Why were there 72 murders in 2020 by people out on bond when there were only 37 in 2015? And so there's, I know these are some old numbers, but it hasn't changed. We have seen a little bit of improvement since the passage of legislation here that required judges themselves, not magistrates, but judges, to set bond and sign their names to violent crime bail documents. That helped. A lot of accountability, light on the issue, and we saw more reasonable bonds being set on violent offenders, not by all of the judges, but by some. That's an improvement. So I think there's hope for jurisdictions that are seeing bail reform trends in their judiciary. You might be seeing them, if you're from an urban area, in your prosecutorial policies. What we're seeing in response to these policies, however, are bills that clamp down on the independence of prosecutors. Okay, that's a problem. That's going to be a real threat to the entire system if every decision we make is scrutinized and we're put on trial. And I don't suggest that's what judges should endure either. But I do think that we're all responsible for our actions, and bail is a 100% judicial responsibility in Texas. And so judges should be accountable for it. I'm accountable for our prosecutions, the number of wins, the number of losses. So I believe in transparency. And the more we get that and the public has access to the facts, I think what you'll see is maybe the pendulum will stop swinging so wildly and we'll get something more reasonable in the middle. At least that's what I keep hoping for.
I don't know, because I kind of want to. I've got a whole big breakdown here. I want to kind of go over. It's basically from the ACLU debate that for your primary race, you and Mr. Tier, I believe, had a debate with the ACLU, and of course they asked lots of questions. But since this is a bail podcast, I want to focus on the one that related to bail, and I kind of want to. The ACLU framed this question, and it's all about the framing. But I want to read the question here because I think it just encapsulates exactly what's going on with bail reform. And so the quote here, the question was, Texas has two systems of justice, one for the rich and one for the poor. If you're wealthy, you usually go free before trial, and you're innocent until proven guilty. But if you're poor, you often stay in jail. Even in the case where the person is found not guilty, they will have spent time away from their family and job, meaning that their children lose parental connections, families lose income, and individuals accused of crimes often find themselves vulnerable and unemployed upon release. Now, that sounds terrible. But
it's meant to. It's when did you stop beating your wife?
Well, exactly. I mean, the framing on that, though, I don't find that to be accurate at all. I mean, you make the argument, two systems of justice, one for the rich and one for the poor. And I assume that you nor any other prosecutor are making prosecutorial decisions based on how much money somebody has. You don't have any money, so I can go pick you up.
Right. No, it's a perspective that is out of touch with reality. And it's out of touch with the facts about who is in jail, what their bond is, what their financial status is. It has more to do with the crime they committed than anything. And in our jail, we have fewer misdemeanor offenders than any major urban area in Texas. And yet I was primaried in part on bail, and my opponent ran on no conditions of bail, and bail is bad. He completely catered to the folks who wrote the question that you read at the ACLU. Right. And because I believe that the district attorney has to serve all people and not just Democrats who vote in the primaries, I gave a much more realistic picture about how bond should be handled. It's not popular. I lost my primary, not so much on bail, but in part because so few people are turning out to vote in our elections, especially our primary elections, that you get skewed results. We talked about extremist candidates. So I remain an optimist, or I would sleep later. But I will tell you that for Harris County, I am concerned about who is going to win the district attorney's race and be the DA from 2025 until 2029, and how that will impact bail. And I think if the public understood the issue better and knew the candidates' positions, they could make a clear decision. But it's kind of like our judicial races. Most people don't know who they're voting for. Many are not voting at all. And I think that this distrust in government in part is coming from the disparity they see between what's being published in the news and what they're seeing in their lives. And I think until we reckon that, you're going to get some of that perspective that there's two different justice systems, because it sure is being pushed. And it's divisive. It's not factual. And it really advocates the dismantling of the justice system. And if you think about what that would mean, it's an extreme concept that just won't work. And yet you read the question that I was asked in an urban area, third most populous place in the country, by people who are promoting that concept. I mean, it's too much. I'll give you one more interesting note about the ACLU. It's not about bail. I believe and support in many of the tenets of the ACLU. I believe in civil liberties. I've had major civil rights cases, and we prosecute police for civil rights violations, which is about as unpopular as bail reform. When I looked through their questionnaire, which they send out to candidates, it was 67 questions. Many were about words we use, about bail, that kind of thing. Not one question was about police shootings. How do we respond to police shootings? So the primary concern, I think, at least of Black Americans, is what's being done when police shoot someone, and how should we respond to that as a society and as a community and as a system? And that wasn't even a question. And yet you read a question about bail that's really not a question at all. It's a manifesto.
Right.
So the political system has weaponized certain issues. Bail is one of them. Your industry is certainly under attack everywhere. My opponent in the primary ran on, in part, that he would take no money from bail bondsmen because you all were basically the reason the system was bad. And without further explanation, bail bondsmen bad. So the message is dumbed down, it's repetitive, it's attack only, it's not responsive to data, and it's probably going to have to be fought politically. Because if you look on the internet, like I said, the research is wildly skewed in favor of bail reform. So you got to look at who's paying for the research.
Yes, absolutely. Now, in fact, I think some of the studies that specifically have looked at Harris County, in their footnotes, thank the Arnold Foundation for their support for this study. It's like, well, the Arnold Foundation is providing the public services or the public safety assessment, the risk algorithm, to help make these decisions. So why wouldn't they have an interest in it? I mean, that's big tobacco lawsuit telling you how great cigarettes are.
I know there's conflicts of interest everywhere. That doesn't seem to bother the proponents of bail reform. I look at the attack on your industry as an attack on public safety, in part because as a line prosecutor, when I wanted to find a defendant who didn't show up in court, I didn't call the Marshal's Service first. I didn't call the warrant division of the sheriff's office. I would pick up the phone and call the bondsman and say, where the heck is your client? He didn't show up in court this morning. And it was effective because you knew where he was. It was not government supervision, which is underfunded and understaffed. It was effective, and I could get the defendant many times back into court, which was the object. The object was not to forfeit the bond. The object was to finish the case.
Right.
And at least from the district attorney's position, and as an assistant district attorney, I understood that was my job. So we've always had bondsmen in Texas. It's actually in the Texas Constitution that every Texan is entitled to bail, except in very few circumstances. I am for expanding the circumstances that judges can hold people without bond, just because the violence in our world is escalating. It's morphing, and I think the law needs to change with that. So I am for giving judges greater discretion in terms of what they can actually hold people for without bond. And that's my public safety concern once more.
Right. No, I mean, and that's something that we always are facing as a challenge is, and that's what happened in New Mexico. The bail bondsmen there thought they had made a deal with the legislature and the courts. Okay, yes, we're going to take this small subset here of people that are really probably very dangerous and give you the ability to preventively detain those people. However, once that constitutional amendment was passed to allow that, the courts themselves, Justice Daniels, who was very much an anti-bail justice, essentially said, either detain or release. Now that we have the constitutional control on this, we're either going to detain or we're going to release everybody. And all you bondsmen, you made a bad deal. And that was essentially the functional end of professional bail bondsmen in New Mexico, even though they worked in the system and thought they had a deal, that was going to limit, that to just the dangerous people. Because again, camel's nose. If we start doing that, that was the same argument in the Salerno case. Which, interestingly, about the ACLU argued against Salerno, argued against the Bail Reform Act of 1984, which would have allowed preventative detention. And now they're out pushing policies that have no end result other than will lead us to preventative detention, because there's no other option. You cannot simply just let everybody go over time. There'll be a public pushback on that.
Well, there has been a public pushback even to what we've seen. One unique thing that happened in Harris County, our political scene is not nearly as extreme as some cities, and our divisions don't seem as extreme. We're a city of opportunity. We have seen people released on 5 bonds, 10 bonds, 15 bonds. That incenses the public. They feel it in the burglaries of cars, which are epidemic. They feel it, and for a family to lose a car, to go get windows replaced, that affects employment, it affects kids, it affects school, it affects everything. So those property crimes that are committed are often committed, we see, by people on bail, but it's the repeatedly violent people who I've taken a strong stance about that have, I think, unfortunately, been the best and most successful tool in turning back some of this unreasonable behavior when it comes to setting low bonds, behavior by judges. And I just hate that it costs people their lives. It's if you look at the data, it's provable without looking at the homicide rate. But you got to look at the homicide rate because those people died as a direct result of a policy change. And that's important. Now, you might have reached the same result without the policy change. Bond could have been set. Defendant might have made it. But never in my 36 years until the last 5 years or so had I seen capital murders released on bond. It just didn't happen. I had never seen anything more than 3 bonds, again, in a lifetime of practicing law here. So there's been
at some point the courts make a determination that this $10,000 bond or whatever, and suddenly if you've been arrested 3 times while this is going on, well, your bond's going to go $1 million, $2 million, because you're demonstrating that that's what it's going to take to make sure that you're not going to go out and commit additional crimes while this is going on. And that doesn't mean that bond is excessive. That means we're looking at the facts on the ground and saying, this is what it's going to take for that. We don't necessarily have to deny somebody bond, but we have to make sure that bond means something and will have an impact on their behavior.
The purpose of those high bonds is effectively to create a no bond situation. It's not to make money for the system. It's not to make you all vulnerable. It's just another way of making sure that the defendant's risk is covered, because that's our job. So I think that we're seeing so many changes nationwide. How this shakes out is going to matter to the future of our justice system. And it's certainly going to matter to public safety. This increase in crime in urban areas, this dismantling of the justice system a piece at a time. I feel like we've seen this movement before in the country, but it seems to be popular with folks who read the news they like. And what we see is that once somebody is victimized and they understand the system, they don't like it. But it almost has to touch people personally for them to have skin in the game. And that's the problem with all reform. I think you get sort of paid advocates, lawyers from firms like we saw Sue and O'Donnell, who are looking to make social changes and win attorneys' fees, and that it has very little to do with what's really good for people. So
there's the old saw that a conservative is just a liberal who's been mugged.
Yes, that's right. And a liberal is that's right. How does it go? A liberal is a conservative who's been indicted, and a conservative is a liberal who's been mugged. There we go.
It's all situational. Okay, so a couple of questions. I know you got to get out of here. Well, we're kind of running short now. So, future-wise, what does the future hold for non-DA Kim Ogg? When we get to the next phase of your life here.
Well, that law license turns out to be pretty handy. So I'm going to practice law. Don't have a home yet, but we'll find one. And I'll be seeing the bail bonding industry. I hope I'll probably work in government relations, and so hope to see the bail bond industry there. So we'll see how it goes. I'm a litigator by nature, but I have a long political history, and I understand the issues because I've lived through a lot of them, and hope to be of service in that way. Still working on public policy and individual cases.
Well, Kim, thank you for taking the time to talk to us today. I know you've got another meeting you've got to get to, so we'll cut this a little bit short than we normally go, but I really do appreciate you taking the time to talk to us. It was really illuminating. Best of luck in future endeavors. Hopefully you can kind of keep track of what's going on and keep the office under control for the next several months. It's still your job. And
absolutely, I can. It's business as usual. I'm still in charge. We're still asking for and filing thousands of motions each year for sufficient bond, many of which are ignored, but we file it, and that's my record. And next time I'm in Kansas City to visit my family, I'll look you up, Shane.
Oh, I'm here. So yeah, I'd love to take you out to eat or something.
Great. Well, you got the best steaks in the country, so I'll be right over.
All right. Thanks a lot.
Take care.
Thank you. We would like to thank our guest, District Attorney Kim Ogg, for taking the time to speak with us today. Houston is a battleground area for bail reform, and she had lots of good information for us. And we hope you'll join us next time for the next episode of the Bail in the Midwest podcast, where we'll continue to bring you conversations with people involved in the criminal justice system, just like this one.
Join us again next time for the Bail in the Midwest podcast, hosted by Shane Rolf.